This reading is for John Carney. He works at the Wall Street Journal. Hopefully one day I'll be able to say he worked at the Wall Street Journal. This is an article by the New York Times, published on February 14th, actually today. Happy Valentine's Day. After the housing crisis, a cash flood and silence, under Fair Game by Gretchen Morgenson, which the name sounds familiar. On August 17, 2012, the federal government began expropriating all the earnings of Fannie Mae and Freddie Mac, the mortgage finance giants that succumbed to the 2008 crisis. Now the government is taking extraordinary measures to keep secret the deliberations surrounding that action. What exactly is it trying to hide? That is the question being asked by a Fannie and Freddie shareholder who has sued the government over the 2012 profit grab. The investor contends that the move amounted to an improper taking of its property. The government disagrees. Margaret M. Sweeney, whatever. Previously undisclosed court records show that the Justice Department has asserted presidential privilege to prevent 45 documents from being produced. These materials, emails, draft memos, and news releases were created by officials at the Treasury Department and the Federal Housing Finance Agency, the overseer of Fannie and Freddie since they collapsed in 2008. The government has also fought every discovery request made by the Fannie and Freddie shareholder. Officials at Treasury and the FHFA claim that disclosure of documents relating to their actions would destabilize the economy and financial markets and raise mortgage rates. Really? The documents the judges ordered the government to produce were created 3 to 7 years ago. How could they unsettle the market now? Even more intriguing, though, is the Justice Department's broad assertions that 669 of the documents it must produce are subject to various privileges and not to be disclosed. The government even claimed that privileges applied to documents it had not yet reviewed, court records show. According to previously undisclosed logs filed as part of the case, most of the documents are said to be covered by attorney-client privilege, or deliberative process privilege, which protects intergovernment communications before a final decision is made in a matter. But the government has invoked presidential privilege on 45 documents created either by officials at the Treasury or the FHFA, the regulator charged with conserving Fannie and Freddie's assets and stabilizing institutions, with the objective of returning the entities to normal business operations. The privilege logs, which are not confidential and were obtained by the New York Times, offer clues about what the government does not want revealed. Logs filed in mid-January, for example, list 231 Treasury documents the government claims are subject to privilege. The 38 items subject to presidential privilege include emails, news releases, memos, and even news summaries circulating between officials at the Treasury and the White House about changing the terms on the company's loan repayment. Logs involve FHFA materials show 438 documents subject to privilege. 7 assert presidential privilege. Additional logs asserting privilege are expected. I asked the Justice Department why its privilege claims were so extensive. In January 28th, in a letter to investors, Bruce Berkowitz, Fairholme's managing member, questioned the broad sweep of the government's claims to secrecy. Why are FHFA and particularly Treasury resisting discovery so fiercely, he wrote. Is it because the document trail directly implicates some of the president's most senior advisors in the White House? Fairholme officials and their lawyers declined to comment further about the case. The question that Mr. Berkowitz raised is more than fair. The problem with the apparent involvement by Treasury and White House officials in the decision to commandeer Fannie and Freddie's earnings so that by congressional statute, the FHFA is supposed to be an independent agency, tasked by law to protect the safety and soundness of the companies. Letting the company's profits flow to the Treasury had the opposite effect, allowing them to rebuild their capital with profits after they repaid the taxpayer seems more like it. If the government has its way, we may never know what involvement executive branch officials had in changing the Fannie and Freddie agreement. But recall what was going on in mid-2012. The presidential election was in full swing, and Democrats and Republicans were clashing over the debt ceiling. That May, in shock to many, Fannie and Freddie reported profits from their operations for the first time since the mortgage crisis, the amount of $4.5 billion, and plenty more was to come. Certainly giving the Treasury access to billions of dollars in the company's profits during this time provided financial flexibility to the executive branch that Congress might not otherwise have approved. Whatever the case, it is disturbing that the government goes to such lengths to shroud the details of the profit sweep decision. It reminds me of a comment made by Ferdinand Pecora, the hard-driving prosecutor who investigated the Wall Street's role in the crash of 1929. In his memoir, Wall Street Under Oath, he wrote, Had there been full disclosure of what was being done in furtherance of these schemes, they could not long have survived the fierce light of publicity and criticism. It's true. Mr. Pecora was writing about the banking practices of the time, but his assertion resonates today. John Carney, you just got owned. Ed DeMarco, man, dude, Bernie Madoff can't hold a candle to you, my man. You know how to steal money for your prior employer. And you know what? What was in it for you? Don't you think? You're an idiot.